veldig Kuhn til å komme og snakke til oss om egentlig hva han vil snakke om. Fordi han en sånn fyr som stort sett snakker om interessante ting. Vi har samarbeidet nå, så han har vært en liten tur i Oslo, før han selvfølgelig lander her. Ja. Jeg lovet dere et foredrag om patenter og lisenser og Copyleft og teknologisk utvikling og sånt. Så får jeg satse på at det er det han bestemte seg for å snakke om i dag.
So unfortunately, I'll be speaking in English. I don't speak Norwegian, I'm sorry. I speak a little Spanish, but that's about it. I'm typical US American, don't speak enough languages. So I'm going to talk about lots of history of copyleft and GPL enforcement. I've done it for two different organizations. I used to work for the Free Software Foundation, which enforces the GPL for the GNU project, so I did it there. My early stories are from that period. And more recently, I work at the Software Freedom Conservancy, which is where I work now, and we do enforcement for Linux, so I'll be talking about that. But first, I want to point something important out. The whole point of all of this is the goal of software freedom. The idea is to make sure that every user who gets software has the inalienable right to copy, share, modify, and redistribute that software. The belief in the community that I live in, the more radical free software folks, is that we want to create a world where everyone has these rights. We want to make sure that our goal is focused on giving these rights to modify your software, to improve it, to learn how it works, to share it with others, to do so both commercially and non-commercially, that all of those rights should be guaranteed. And that's the final goal. Copyleft is a strategy to reach that goal. Many times in our community, developers think of copyleft as if it is some sort of principle, if the GPL is a moral imperative unto itself. I'm probably the most pro-GPL person in the world. I don't believe that. GPL is a tool to try and reach a certain goal. And it's important not to think about it as if it's a principle of its own, because if the tool does not work, we shouldn't use it, or we should change how we use it. And I'm going to be giving some examples of places where the tool has been misused by others, has been abused and manipulated. And so I think it's important to think about in terms of that. And remember that software freedom is the goal that we're trying to reach, not more copyleft necessarily. Copyleft is just one possible method to get there. So this is a rather formalistic definition of copyleft. I originally got this from Wikipedia. I've actually edited it and improved it myself a little bit. I'm not going to read it out, but I think it's important to have a real grounding in a kind of a formal way of thinking of what copyleft does. More simply put than this, copyleft is a type of license that works under the copyright system we have to pursue the goals of software freedom. The most common copyleft license that many of you have probably heard of is the general public license from the GNU project. And that is a detailed implementation of legal rules written into a license to help ensure that when you get a copy of software, your rights of software freedom to copy, share, modify, and redistribute that software are guaranteed. So I'm going to be talking mostly about the GNU GPL, but the first thing I want to point out is that copyleft is not magic. It doesn't work by itself. A lot of people think that you put the GPL on a program and then magically your software is free forever and that's assured. In fact, it's not. The copyleft licenses like the GPL always operate under copyright, which means the mechanisms that are typically used under copyright to ensure that a license is adhered to and followed are the same methods that we must use for the GPL and copyleft licenses to ensure the same. So we have to actually do work because copyright does not enforce itself. Copyright is a civil system that you can use as a citizen to enforce your rights and guarantee your rights. But you have to do that work. It doesn't work magically. So broadly speaking, GPL enforcement is the process of going into the copyright system and assuring that when someone fails to give software freedom to a user, they take GPL software and add proprietary software to it or modify it and don't share those modifications with those they distribute to, you can use the copyright system to enforce the license. The proper goal, in my view, the moral goal with a GPL license and doing GPL enforcement is to ensure that when a user gets a product, when you go to the electronics store and buy a television or a mobile phone or a wireless router, more often than not these days, that will have Linux in it and lots of other GPL software. My view is when you get that product, that's often the first opportunity, especially for kids, to have access to free software. That's the first devices they often use. And from my point of view, they should be able to immediately begin to participate in the upstream projects that are generating the software that ends up in these devices. So that's the first thing that I'm seeking when I see GPL software in a product. I want to make sure that people can actually modify that and be able to actually make direct use of that software freedom. So if you have Linux in a device, you should be allowed, and the GPL guarantees that you should be allowed to modify that copy of Linux and reinstall it on that device, on your TV, on your wireless router. Now, when we do this process of enforcement, we have to be sure we're, as I said, reaching the goal that we actually want, because we're using a strategy, and there, I think, are other important things we have to consider. About a year, I guess less than a year ago, about 6 months ago, my organization, the Software Freedom Conservancy and the Free Software Foundation, published together these principles of community-oriented GPL enforcement. And the reason we did that is because we saw other people using GPL enforcement for other uses, other goals that were not necessarily the goal of software freedom. So we've tried to embody the principles that we've used for years in GPL enforcement into a clear document. They were sort of unwritten rules that we all followed when we tried to do enforcement for software freedom. We've now written those down. So there's a link there on the site. And by the way, these if you go eb.org/bkuhn/talks, if you want to click on links while I'm speaking, feel free. Anything blue on my slides is a link. Now, it's not just about getting people involved in the upstream communities. That's important. We want to recruit developers to work on Linux and other GPL software. But in some sense, that's actually secondary. And I'm not as concerned about what happens to upstream projects so much, as it turns out. I think Linux is a pretty healthy project. And regardless of how many times the GPL is violated, Linux is going to continue and succeed as a project for a long time to come. It doesn't necessarily need every last GPL violation to be resolved to succeed as a project. But the important thing to remember about what GPL is designed to do, it's a license mostly for the users, the end users of the software, than it is for the upstream developers. While the upstream developers are the ones who make the decision to apply the GPL to a program, the beneficiary of that license is primarily the people who get a downstream device. And they, of course, as I mentioned, may be future developers, but those are the people I'm most concerned about. When you buy that television, wireless router, mobile phone, I want to make sure that you, as the user, have the right to modify it and improve it and see how it works and see what changes the vendor made from upstream, because most of them have made some changes. And I'm very concerned. I'm going to talk a lot in the next hour about this issue of how you make direct use of that software freedom. Things have changed now that we have embedded software in the last 10 or 15 years. It's much more complicated to upgrade a device. You have to do cross-compiling, you have to burn a firmware onto the device or reflash it. So those types of things have become important in regards to exercising your software freedom. And I'm going to talk a lot about how that's caused problems in enforcement and how we've dealt with it. But I always want that freedom, that software freedom, to be a real thing you can exercise. It can't just be theoretical. We're not succeeding in the goal of making a world where all the software is free software if people have free software, but they can't actually modify the software on their device. It's there, and they can maybe look at the source code, but they can't actually do anything with it. That's a problem. This freedom has to be concrete and real. So what happens when there's a GPL violation? How does that come to be in concrete terms? Most people have a basic understanding of, oh, I didn't get the source code. But there are actually some details in the license that actually say what it means when something's a violation. The two most common versions of the GPL in use today are GPL version 2 and GPL version 3. They're both in active use. And what they say is that when you make a new work based on the work that you have, so when you get a copy, for example, of Linux, and you base a new work on that, i.e. you modify Linux or add a device driver or other types of additions to Linux, the GPL says that the entire work has to be licensed under the same license. That's how it creates the share and share alike effect, because the license says that when you expand the work, you have to apply the same license to your existing work. And in legal terms, what that means is that all the copyrighted material, because remember GPL is a copyright license and based around copyright law, all of that material has to be licensed under some terms that are compatible with the GPL. And that's important to note because there are many licenses that aren't actually GPL, but they're compatible. The 2-clause and 3-clause BSDs are compatible with GPL, and MIT license is compatible with GPL. So it's possible to incorporate other free software works that aren't copylefted into a GPL program. The other thing that the GPL legally requires is that you get the complete corresponding source code, or in the GPL enforcement world, we call this the CCS. We abbreviate it to an acronym. And that's the key part of that concrete right to modify the software. You have to make sure the source code that you get is complete so that you can actually make use of it and recompile the software and reinstall it. If it's not complete, you won't be able to do that. The next part of how the GPL works when someone violates it is if you fail to do these things at the top here, if you fail to give the complete corresponding source code, if you fail to license the whole work under the terms of the GPL, in those cases, your license terminates. You no longer have permission under copyright law to do the activities that copyright law governs, which are typically copying, modifying, and distributing the work of software. So if you take Linux and you make a proprietary device driver, automatically under GPLv3, you lose your permission to distribute the software. So if you, for example, are a TV manufacturer, you've put Linux in your TV, you've added a proprietary device driver, you've failed to give the users the source code to that, the moment that happens, you can no longer ship that TV. So that's the leverage that we get. We can use the court system and other means to say, you're not allowed to distribute that TV anymore until you comply with the GPL. And we use this as our key leverage. We say that to companies that, hey, we send a cease and desist letter. It's very legalistic, admittedly, but we tell them you can't distribute this anymore. But what we want you to do is actually very simple. We want you to treat the community well and release the source code. And that's something you can do, and it will resolve the problem. So that's how the center of a GPL violation and GPL enforcement works. I want to now switch to giving you a short history of how the GPL came to be and how it's been enforced. So the first program ever to be licensed under the GNU GPL is GNU Emacs. Does anybody know what Emacs's license was before the GPL? So in fact, Emacs was the first copylefted program ever. And it was under a license called the Emacs Public License, which was specific to Emacs. And I think this is an interesting curiosity in history because people don't realize, well, first of all, when they see GPL, all the time people say it's the GNU Public License, which you know someone doesn't know what they're talking about if they say that, because the G doesn't stand for GNU, it stands for general. But the reason it stands for general is not because what most people think, which is it's for the general public, which is a term in US English in particular that means the whole public, the general public license. It's not why the word general is there. The word general is there actually to indicate that there used to be various different specific public licenses, one for Emacs, one for other programs, and the GPL is the generalized version of that. So it used to say in the Emacs public license all the things you could do with Emacs, and that was refactored so that program was a variable instead of being a specific name of a program. And there's actually, you can find online documents about how the FSF celebrated when they published the generalized version of the, we've refactored our license and now it's generalized. So that's why Emacs ended up being the first GPL program. In all these years, I've never heard of anyone violating the license on Emacs, ever. No one's ever tried to make, as far as I know, a proprietary version of Emacs. There, of course, is a very famous fork, Emacs, but they have always, to my knowledge, complied with the GPL and done what the GPL requires. It's actually a great tribute to what the GPL allows, because the Emacs fork has continued on under the GPL, even though GNU Emacs has continued on as a separate code base. So the second copyleft program is where we first start to see GPL violations. That was GCC. In fact, GCC was originally under the GCC public license and then was then released under the general public license when it was available. And this is the type of program that companies started to realize they could effectively exploit. It was well designed for its day. I realize that most people think GCC is not well designed now, but in the 1980s, late 1980s, it was revolutionary with regard to compilers because it had separate front ends and back ends, and you could write new front ends, and it didn't necessarily affect the back end code generators. You could write new back ends, and then immediately all the front ends worked on those new back ends for different processors. And it really revolutionized. Stallman actually just won an ACM award for his original development of GCC because it was so revolutionary at the time. But it also meant that companies were rather excited and desperate to make use of it, but they didn't necessarily want to share their changes under the GPL with the community. Does anybody know who the first GPL violator in history was? It's actually a very interesting historical artifact of who the first violator is. Does anyone want to guess? You can get the person or the company. So Steve Jobs was the first person to violate the GPL when he was at Next. Next was developing this language called Objective-C, which later became much more famous as the language of development for the iPhone and other Apple platforms. But he was designing this language with his engineers, and he discovered GCC and said, oh, what we can do is we'll write a front end, because it has this great thing where you can write front ends, you get immediately access to the back ends for all the different architectures. We'll write this front end for Objective-C. We'll release it only as object code. And you can always just download the new version of GCC, recompile it, link it in with our object code for Objective-C front end, and then basically we'll never have to release that source code. So Richard Stallman has written a very famous essay in the mid-90s, I think, about doing this GPL enforcement action. It's unfortunate that so much of this is not written down. One of the reasons I like to give these talks is because so much of GPL history is not written down. And this is another case. I've actually asked Richard Stallman twice. I know him pretty well and speak to him often. And I asked him once years ago, probably when I started giving talks about GPL like 10 years ago. I asked him, so did you meet with Steve Jobs? Did you talk to him on the phone? Like, how did the enforcement action happen? He goes, I can't remember it all. And I said, okay. I used to tell in talks like this, I would say, hey, isn't it amazing that most of us, I think me included, if we had met Steve Jobs at one point when he was alive, we'd all remember, right? It's not something you forget. I thought it was very neat that Richard Stallman just didn't care. And he's like, I don't care who he is. He's violating the GPL. And he didn't remember. But I asked him about 2 years ago, I told him that I tell that story in all these talks. And he said, no, I went to their offices and met with them. And I said, but Richard, you told me 10 years ago that you didn't remember. He goes, very Richard Stallman answer, he says, yeah, 10 years ago I probably didn't remember. So I don't know. So anyway, but his memory is clearly not certain on this issue. So I looked for online documentation, details of what I could find of the violation before Stallman's essay. Stallman's essay is sort of the essay of record on this topic about enforcing on Objective-C. But the only thing I could find, I scoured Usenet archives for this. And so I found this email. Now this email is late in the history of Objective-C. Objective-C had been around, I think, for a couple of years, or at least a year by then. And this poster is referring to some book, which means it got to the point where somebody had published a book about Next, and it mentioned the Objective-C compiler. So I think this was after the enforcement action had happened. And this is an interesting thing of politics, right? So this guy goes on Usenet and posts and complains that it's violating the GPL. And then 3 days later, somebody from Next answers. And of course, it really is only 3 days. And Usenet time clock, that's very fast. It could take 3 days for this person to have received the message in the first place from Usenet. So this was political theater in my point of view. I don't think that this is the real how it happened, that Next found out about the violation because somebody wrote a book and then they fixed it 3 days later. Very unlikely. I've only once in my life had a GPL violation fixed faster than months. So I think this was a political theater for Next to show that, hey, we've always meant to do the right thing. And in fact, they didn't intend to do so. It was only because GPL enforcement happened. And I'm going to talk a little bit later about sort of the fallout from what happened. This being the first violation, we still live with its consequences and the complications related to it today. The next era of GPL enforcement was the era that when I actually got involved in the late 1990s. there was a period in the late 1990s when tape backup systems were really important. People still do tape backup today, but not like we did in the 90s. I once had a cubicle at an office that the drawers were just filled with 8mm tape. That's all I had in any drawer in the entire big cubicle. Like it was this size, and it's all just magnetic tape. Because disks were big enough that you couldn't just, and expensive enough, you couldn't just buy another disk to back up. You had to back up to the cheaper magnetic tape, and we had robotic arm drives and all these sorts of things. And pretty much every company that was a major technology company that sold products in the late 1990s had a tape backup solution that they would sell you. And almost all of them were based on GNU Tar, because GNU Tar was the best implementation of Tar, the tape archiver, available, and they all used it. And what happened in this era is it turns out that sysadmins are some of the best people to discover a GPL violation, because they're the type of people that actually want to know how something works. They're not willing to just assume that the software is going to work okay. They want to know, and they want to know the details. And so over the years in the late 1990s, the FSF, where I was a volunteer and then worked for a time, would get plenty of GPL violation reports about GNU Tar being in these various different tape backup solutions. And this is when I first got involved with the GPL enforcement effort. This is the first time I personally was involved in enforcing the GPL. And I started by doing this thing we call the CCS, or Complete Corresponding Source Code Check. These days, it's much more complicated than it was in the old days. But the basic idea is this. You've identified a GPL violation. You've told the company you were supposed to give us the complete source code of this. You did not. And you have to fix that. Otherwise, we're going to prohibit you from distributing the software anymore. So you have to give us a source code candidate so we can review it to make sure that it actually matches the binaries that you distributed. Because again, the source code has to match the binaries for it to actually be compliant with the GPL. So Stallman sent me in this sometime in mid-year 2000, probably February 2000, sent me this copy of a GNU Tar release that one of these companies was going to make. And I was deciding on the plane here to Norway whether I should mention the name of the company. This is now 16 years ago. But yeah, I don't think it's fair, and I'm going to explain more why. But I'm still not going to tell you what company this was. I can tell you they don't have a tape backup product anymore. But they had modified GNU Tar to support various other file systems this is the old days of the fractured Unix environment with HPUX and AIX and Ultrix, et cetera. So they had modified GNU Tar to do special things for different types of file systems, optimizations, those sorts of things. And I discovered in reviewing the source code why they had been so reluctant to release the source code. Because their product claimed cryptographic support, encrypted backups. And I realized when they finally released the source code that in fact it was a certain amount of security through obscurity. Because as far as I could tell, I never actually ran the product, but looking at the source code, it was clearly writing the passphrase because it was just symmetric encryption, right? So it would write the passphrase to the first block of the tape and then write out the tape encrypted, which meant if you had the tape, you had both the key and the encrypted data. So I don't know how that's actually a cryptographic backup solution, because if I steal your tapes, I have all your data anyway. So what difference does it make that it's actually encrypted on the media? Because you gave me the key as well when I stole your tapes. So I think this is probably why they didn't want to release the source code initially, as their cryptographic solution was not actually a bona fide security solution. It was just security through obscurity. So anyway, they don't have this backup product anymore, so you don't have to warn your companies you might be using such a backup product that's long gone, very long ago. But this is how I got involved doing these CCS checks. I'm going to talk a little bit later of how complicated these CCS checks get in these days. But the thing I want to note right now is how important it is that the GPL has a legal side, and it's admittedly, and some people don't like that about GPL, that there's a legalistic aspect to it. But it's also very technical, because Copyleft's goals, at least for software, are trying to make sure that people can do certain things with the software, making sure that they can modify, rebuild it, improve it, and so forth. So you can't actually enforce the GPL just with lawyers. I do work with a lot of lawyers. I'm not one, but I spend a lot of time with them. People say I sound like one, which really is insulting. But I mostly do technical stuff. Doing these kinds of CCS checks, I'm now a manager, so I manage the person who does the CCS checks. But it's really important, and the process has gotten very complicated in embedded systems because embedded systems, the source code release is usually a cross-compiler environment, and we have to know how to update the firmware. But the GPL does require that those things be possible. It has to be possible to rebuild and reinstall the software under GPL. And so we talk about it in the formalistic sense in enforcement. I say this as we, but I invented a lot of this terminology, and so I just made it up. So we say the CCS adequately meets the GPL's requirements. That's kind of how we think about it in a formalistic sense. Now this thing, complete corresponding source code, CCS, is defined in both licenses. I show the definition from GPLv3 first because it's simpler. This is not the full definition from v3 though, so I'm sort of cheating, saying, oh, GPLv3 is simpler. In fact, there's a separate definition of what's called installation information that I'm going to talk about in a few minutes that I don't show on the slide here. But this is the basic definition of what GPLv3 calls corresponding source is a defined term, but for years I had done GPLv2 enforcement, and frankly much of my thinking and terminology is still based around GPLv2, and this is the part of GPLv2 that talks about it. So the phrase complete corresponding source comes from complete corresponding machine readable source. So I guess we could have called it CMR or C or something, but CCS seemed fine. Actually, as a historical note, you'll find me writing about this earlier in the 2000s, calling it CNCS with an ampersand. And a colleague of mine, Aaron Williamson, once pointed out, says, the word end is not in that phrase, A and D, the connector. So calling it CNCS is not right, complete and corresponding. So we switched to calling it complete corresponding source code. So this is the legal details of the license, how it requires that this source code be available. And from my point of view, this part of the end is actually the most important part of GPL v2's CCS definition. These 11 words are in a lot of ways in the embedded space the most important part of GPL v2. I have not written one yet, but I could actually give an entire hour talk on these 11 words. I can actually spend probably 20 or 30 minutes on what the significance of the in the scripts. I've actually had hour-long conference calls with lawyers about the word the as it appears there. This is how lawyers are. And I'll give a brief preview of that. Basically, the question does the scripts mean it has to be the scripts you actually wrote, or can you give me any scripts that work? We can discuss that question for hours. So when we're in an enforcement process, the lawyers want to argue, and I'm going to talk more about how the other side has gotten more aggressive and less friendly over time. But the thing is that I always find it unfortunate when an enforcement action ends up arguing about these words, because what we're really trying to get at is if I hand a developer who's reasonably skilled at building embedded software, can they build the software and install it? That's what those words are getting at. Are they able to do whatever process it is to get the software built and installed? And that's what we're doing when we test these complete corresponding source code candidates, like that one I got for GNU Tar. That was a pretty simple one because in the days before embedded software, that was a copy of Tar that just ran on a regular old Unix system of any sort. These days, it runs on some target platform that's a tiny device like a phone or a CPU or a system on a chip and a TV. And so we often have these many iterations of them giving us a CCS candidate that we try to build and it won't build. Now, the question of compliance is a binary question. Either the software is in compliance with the GPL or it's not. However, binary answers aren't always helpful. So what we normally do when we take one of these CCS candidates is we review it, we give them the binary answer, which is unfortunately usually 0. And then we say, here are the things we found that made it impossible for us to build or install the software. So these are the things you have to fix to try to get the answer to a 1 next time. These days in the embedded software world, the quickest turnaround time is usually 3 or 4 of these candidates. The longest I've ever done is 28 times. They sent us a source release. We tried to build it. It didn't work. We sent it back. And 28 times later of that loop, we got a source candidate that built and installed. In fact, this was during one of the court cases, which I'm going to talk about the court case later, but they kept telling the court that we were giving them a moving target that kept changing, and we kept changing our advice. In fact, from candidate 14 to like 21, we sent the exact same problem each time because they never fixed those problems. So in fact, the answer was the same every time. We said, these 10 things you haven't fixed yet. So it wasn't really a moving target. They were not moving towards the target that was stable. So throughout the late 1990s into the early 2000s, this tar problem continues. And I would say up until about 2002, GNU Tar is the most widely violated GPL program from like 96-ish to 2002. I was surprised at how often people were making these forks of tar to make these backup. I was a sysadmin at the time, in the mid-90s. That was my main career, and we used backup solutions, but it wasn't like I was surprised that there was such a big market for custom backup solutions based on proprietarized versions of GNU Tar, but there was. And over time, everybody came into compliance. That market, we pretty much cleaned it up, the bad actors, except for one. The last time I did this, at this point, I'm already the executive director in 2002 of the Free Software Foundation, so I'm in charge. And we're still working this old GNU Tar violation we had. And I went to the Linux World Expo in San Francisco, California in the US, which used to be the biggest trade show in Linux in those days, in the early 2000s. And the lawyer who was working on this matter, and again, I want to name the company, but I'll tell you why I don't name companies in a few minutes. He calls me and said, well, he's based in San Francisco, so he's not even going to the expo, but he calls me and says, would you like to meet? I'll buy you lunch. And I should warn everybody, if you don't work with a lot of lawyers, if a lawyer wants to buy you lunch, it's bad news. If you want to be buying the lawyer lunch, because that means they're helping you, but if they want to buy you lunch, it's bad news. So he bought me crepes at this very famous crepe place in San Francisco, and he tells me, I say, when are you going to get us a CCS candidate that I can check? And he actually says, no, what we're going to do is we're going to remove tar entirely. We're rewriting our own tar from scratch. We're not going to use GNU Tar anymore. And so I walk back to the train system in San Francisco. It's called the BART, the Bay Area Rapid Transit. So I'm walking back to the BART train to go back to the conference. And I get on the mobile phone, and I'm immediately calling our lawyer saying, well, we're going to sue these guys because they're not going to give us the source code. They made modifications to GNU Tar, and we're not going to get it. And this is when I really started to understand how GPL worked. I would say up until this time, I didn't really have a good understanding of how GPL really interacted with the copyright system and the courts, because the lawyer said, well, we can't sue them. It will never succeed. And I was like, well, what do you mean? We go to the court, and we tell the court orders them to release the source code. That is probably unlikely to ever happen in a GPL enforcement case where the court actually orders someone to release source code. And it's funny to think about because that's the big fear, right, that people have. If I screw up about GPL, a court is going to order me to release the source code I didn't want to release. Well, that actually never really happens because around the world, in the US and throughout Europe, I'm familiar with those legal systems. I don't know much about other legal systems, but every lawyer I've talked to in every jurisdiction I've met a lawyer from has told me there's two remedies that courts give you. They give you money. Courts love to give you money, actually. They love to say, you were wrong, that this person did something they shouldn't have done, you should get some money for it. And that's true actually around the world. More so in the US than here, but generally speaking, courts like to do that as a remedy when you have some injustice that's been given to you. The other thing they like to do is to give what's called an injunction. What an injunction is a prohibition from doing something. So when the idea of a court ordering you to release source code, that's what they call in legal theory specific performance, I think they call it, or special performance. I think it's specific performance, like telling you to do a specific act. Courts rarely like to do that. They don't like to tell you you must do something. They like to tell you you may not do something. So they will happily give you an injunction if someone's infringing your copyrights, because ultimately a GPL violation is a copyright infringement. They will tell a violator, you may no longer distribute GNU Tar. You have no permission to the Free Software Foundation's copyrights on GNU Tar. Therefore, you may no longer distribute it. And the fact of the matter is, when a company says we're going to rewrite Tar from scratch and we're not going to use and include GNU Tar in our product anymore, they've granted you a de facto injunction. So they've given you half of what a court's likely to give you anyway, just by their own action. So in the end, there's no point in suing them unless you're obsessed with avarice and you want to get more money. I'm going to talk about that, why we don't do that later. So at that point, it's useless. We've gotten compliance because the thing I didn't know until 2002 is that one way to comply very easily with the GPL is do not copy, modify, or distribute any GPL software. That's always compliance by default. Oh, it's kind of the base case of compliance. So that's what they were going to do now. So they were going to be in compliance. Now, the interesting side effect of this is this company is still prohibited to this day, in a legal sense, from distributing GNU Tar. And every 6 months or so, I still am in regular communication and on the board of directors of the Free Software Foundation, so just as a volunteer these days. But I always remind my colleagues every 6 months or so, you do know that company, I won't name it here, they're still not allowed to distribute GNU Tar. And this company, they stopped making a backup solution long ago, and I don't think they've ever distributed GNU Tar since then. But I always remind my colleagues, if you ever see that, remember, they never came into compliance, they never released their source code, which means they're permanently enjoined, although we have to get a court to confirm that. But I think we could pretty easily, given these historical facts, get a court to assure that they can never distribute it again, which is not really what we want. I would rather them join the Tar upstream community. I would rather them started giving patches to GNU Tar. But that's not what they wanted to do, and ultimately that's their choice. So this is where we begin the next era of GPL enforcement. This is the wireless router era, which still continues on to this day. So in spring of 2003, at this point, again, I'm the executive director at the FSF at the time, we start receiving dozens of GPL violation reports regarding the WRT54G. And some of you may know wireless router history better than me, but as far as I know, this is the first wireless router that had Linux in it. And as it turned out, just weeks before that, this was a Linksys branded router, but Cisco had just bought Linksys about 6 weeks before this all happened. So we're on the phone at this point with both Cisco and Linksys. We have them all on the conference call. And these days, in fact, because of this case, there's an obsession in the legal community about what they call compliance certification for M&A, which basically means when you do a merger or an acquisition of a company, you vet all their adoption of open source and free software to see if they're complying properly with the license. Not just GPL, but also the BSD license, which requires copyright notices be maintained and so forth. And there's an obsession in the legal community, in part because of this case, that when you acquire a company, you've got to check this, because they may be bringing to you a bunch of legal risk because of open source and free software licenses. And now, one of the things we always do, and I'm going to talk more about why later, is we really try to stay confidential in discussions with GPL violators. I've always found that they're more likely to come into compliance quickly if you can use the fact this is not public yet as leverage. And we don't want it to be public. We just want you to quietly begin complying with the GPL, and we're never going to go out. Even to this day, I'm afraid to say names of companies from 16 years ago that violated the GPL, because I think that's an important thing to do, and it's an important piece of leverage. Unfortunately, anybody who bought this wireless router, you could actually go into the web interface. And there's one that, a lot of these have the web interface to view the logs, right? And you could read the logs and you could tell it was a Linux log, right? I mean, it just looked like syslog. So it was obvious to anyone who bought this router that it was Linux-based. So the story on June 8th, 2003, we're almost at the 13-year anniversary of this happening, a couple days from now. The story hit Slashdot. And Slashdot at that point is the premier tech news site in 2003. It's what everybody read at that point. And so to this day, I think the lawyer at Cisco, a guy named Sherman Chu, thinks I put this story on Slashdot. In fact, I was desperately trying to prevent it from hitting Slashdot because I was trying to negotiate with them privately. I actually called Rob Lamo, who was one of the guys on Slashdot, and complained to him right after it went up. I'm like, look, I'm trying to resolve this thing, and now you got it all over the website. And at that point, it was out. So things got tense in the discussions with Cisco and Linksys at that point. And we knew it was going to be a big enforcement action. So the FSF only had a few copyrights, as it turned out, in this product. Most of the copyrights were other people's, but under the GPL. So we built a coalition. And if you remember this time, this is a joke, right? Because if you remember what time this was, what was happening in June 2003, Coalition of the Willing is the fact that we were able to laugh at ourselves, right? I mean, it's not what you, in 2003, what you want to call your coalition, if you all remember what was going on in world politics at the time. But one of my staffers, Dave Turner, said, we should call it the Coalition of the Willing. I'm like, I don't want to call it the Coalition. He's like, no, it'll be funny. So it was funny. So Eric Anderson from the BusyBox project and Harold Velta of Linux, and particularly NetFilter, were the people most heavily involved with us in this coalition. And we went forward as the FSF, where I worked at the time, basically representing the entire coalition in the negotiation. And this is when I discovered what I call the upstream problem, which is, in some sense, Linksys was upstream from Cisco, although they were the same company at that point. But Linksys had just sourced a system on a chip from Broadcom with a wireless card and everything. And so Linksys didn't have any of the source code either. They'd never gotten it from Broadcom, as it turned out. And we actually had to negotiate mostly with Broadcom to get the source code released. And they insisted on not releasing the wireless driver for the Broadcom chip. And I actually think that wireless driver to this day has still never been released for that particular chipset, which is no longer used in modern products. But it's still proprietary. And there was this argument about whether the Federal Communications Commission, which is the spectrum regulator in the United States, would have a problem with them releasing a wireless driver. That's been disproven since then because other companies have released wireless drivers and had no problem with the spectrum regulators. But in the end, there came to this conclusion we weren't going to pursue the matter. The FSF didn't have copyrights in Linux itself, so there was no really direct way for the FSF alone to do this. And it sort of just became, we're going to have to accept a continued violation on Linux and not get this wireless driver. And I'm going to talk later about why I regret doing it this way, because I think it's led to the problems we face today. But the nice thing about it is that if you look at the old SVN tree, which was how OpenWRT started, they used SVN at the time, it was 2003. The first check-in, revision 1 in that SVN tree, is the source release we got from Broadcom. Once it was released, that's what launched the OpenWRT project. So I'm pretty proud of this enforcement action because it shows GPL enforcement can create a free software community. OpenWRT, I believe, would not exist if not for us doing this enforcement action, because that's the source code they used to get that project started. And I think that was really important. Another weird side effect of this enforcement action was Harold was incredibly angry about it. He was very frustrated. He felt, we used to have these conference calls every few weeks, because this took about a year and a half, all told. And we'd have these conference calls, and at the end of he would be silent the whole conference call. At the end, he would say, "When are you going to sue Cisco?" And the FSF was really afraid to sue Cisco. The FSF eventually sued Cisco, ironically, years later, because they kept re-violating the GPL. But there was this sense inside the FSF at the time that lawsuits were going to be dangerous, that they would hurt adoption of free software, that it would basically justify the BSD's community claims about the GPL being too legalistic, right? I mean, that this would basically be the death of the GPL as a strategy if we did lawsuits. I think Harold was right all along. I told Harold, I only see Harold every 6 or 8 months at a conference, and we often don't get time to sit down, but we had a few minutes to talk back in April. We were both at the same conference, and I said, Harold, I say in my talks all the time that you were right. You were always right. And Harold, he looks at me and says, well, I was really young, and I was just willing to take risk at anything, and I figured I could sue anybody, and I didn't care, because I was in my 20s. And but I think that level of just saying I'm going to do what's right and what my rights say I'm allowed to do. We need a certain amount of risk taking in our community to do what needs to be done. And Harold really is probably I guess after me, is the most prolific enforcer of the GPL. Through the mid-2000s, he did about 8 different lawsuits in Germany against GPL violators. He got a lot of source code released that wouldn't have been released otherwise. He did really important work, and he did it all with the courts. He did it all with lawsuits. And he did run into that problem that I talked about, though. There are some of his lawsuits, if you look at the final announcement of the lawsuit, they don't actually release any source code. What they do is they stop including Linux in their products. And so that's a problem we face, that we can't get a court many times to order release of source code. We can just get them to order injunction. And then hopefully the company will release source code. During the same period, roughly same period, I'm still working at the FSF up until 2005 is when I stopped being an employee of the FSF. And I was really focused on the embedded industry's adoption of GCC. GCC became the default toolkit in the embedded industry because it was ported to all the different system on a chip already. All the processors had a port for GCC. And we did a lot of work trying to prevent companies from building proprietary SDKs. A lot of companies tried to take GCC and included it in some proprietary SDK, add some features to GCC and keep it proprietary. And we focused a lot on GPL enforcement to make sure that that didn't happen. And so that was the kind of focus of the GPL enforcement I was doing at the time. During the same period, we started to see, I mentioned early in the talk, I would mention some of the sort of incorrect uses of this strategy. This is during the same period as the rise of MySQL AB and its business model, which has been often imitated at this point. It's a very common business model that venture capitalists encourage quote open source unquote companies to do. And the idea is this. As I mentioned, GPL is a copyright license, which means that if you have all of the copyrights, you are the sole licensor. Now, you can put a version under GPL out there in the world. That's permissible under copyright rules. But copyright rules also allow you, if you're the only copyright holder, to offer different licenses if you want to, including proprietary ones. So what companies like MySQL AB, which is now part of Oracle, do is they do GPL enforcement effectively for profit. They go around to companies and say, oh, well, you've got MySQL in your product. No, we don't actually want you to comply with the GPL. We don't care about that. We don't care about people getting source code. What we want is for you to buy a non-GPL license from us for some fee. And it really becomes a shakedown system where MySQL AB and now Oracle will go to companies and say, oh, gee, you have some PHP files that have SQL statements in it. Our lawyers tell us that makes it a derivative work of MySQL server, which means you have to release all your PHP code under the GPL, or you have to buy a proprietary license from us, which we'll happily sell you, and we have a sliding scale of how much we charge you based on the size of your company. So it's all very reasonable, they say. Just buy this license. Now, I've been accused of having a very expansive view of what is a derivative or a combined work under the various different copyright systems in the world. GPL relies on the fact that there's a relatively expansive view under law of what it means to be a derivative work, which is how the copyleft clause works. It says once it's a derivative work under copyright law, you have to license it under GPL. I do not believe that if you write SQL statements in a PHP file, that it makes your PHP program a derivative work of the SQL server you happen to be using. But most people don't understand these topics. I'm a developer originally and a sysadmin, and I've studied sort of amateur study with lawyers for years to understand these concepts. But most companies don't have an expert who understands them. So when MySQL comes to your door and says, we're going to sue you for a lot of money if you don't just buy this really cheap proprietary license, the shakedown often works. And this is an example where it's really important not to think of the GPL as a principle unto itself. This is corrupt. This is wrong use of the GPL. And I took a long time myself to understand that, and I'm trying to warn the world that not every use of the GPL you see out there is a good one or an appropriate one. And we as a free software community must draw attention to the fact that there's a way to use GPL to help free software, and there's a way to use GPL that hurts free software, and this is one of the ones that hurts. And this is, I mentioned this again, this is why we publish these principles. These are principles that I've always followed in my work, but we wrote them up and specifically said, if you're following these principles, you're doing GPL enforcement for the good of the community. But if you're not following these principles, it's a question, open question, whether or not you're actually helping the community by the work you're doing. So as I mentioned, I was mostly working on GCC enforcement up until around 2005 when I left the FSF. And in around mid-2006, Eric Anderson, whom I'd worked with on the WRT54G enforcement with Linksys and Cisco, emails me and says that he's becoming increasingly exasperated. He's been working on BusyBox for about 4 years, 5 years at this point. He wasn't the original author of that project, but he really was the one that led it into fruition. He has 40% of the copyrights in BusyBox even to this day, I think. Well, Dennis Vlasenko probably has more now, but certainly up until about 2010, he was still the primary copyright holder. And he just saw BusyBox in all these different products, and no source code was offered, and it was just proprietarized everywhere. And he asks if I'll help him do enforcement again. And it was right around this time, actually in April 2006, we had formed the organization I work with now called the Software Freedom Conservancy. And we're more generally, I'm not really talking about this in detail in this talk, but we provide just general services to open source and free software projects of all sorts and all types of different services. But one of the services that we can provide is enforcement services for licenses. We actually do enforcement for GPL and non-copyleft projects. I've even done enforcement on the MIT license, failure to display copyright notices. So this is something we do for our projects. And I said, well, why doesn't BusyBox join the Conservancy? And we can be your enforcement agent. So Eric didn't assign his copyrights to Conservancy. I'm not a fan of copyright assignment anymore, which I'm happy to talk about during Q&A if people are curious. But what we did is we signed an agreement with Eric, whereby he appointed us his enforcement agent to be allowed to enforce his copyrights on his behalf so he could focus on development of BusyBox while we enforced the license. And later on, actually, a number of copyright holders who wanted us to enforce but didn't want to be involved in the details actually just decided, oh, I just want to assign my copyright. So we actually did receive some copyright assignments anyway. And ever since that point we've always had greater than 100 known GPL violations. We published an address to report violations on BusyBox, and we got hundreds immediately. And this list is always greater than 300. It's probably closer to 1,000. I can't even catalog it. I just have a giant email folder of all the GPL violations I know about, and it's a lot. There's thousands of emails in that folder. Of course, many of them are about the same violation, so I don't know the exact count. But there are hundreds and hundreds of any given time of people violating the GPL on BusyBox or Linux out there in the world. And this was at the point where I started to realize Harold was correct, that we needed to use lawsuits. There was no option because there was going to be hundreds of GPL violations, and if you don't, frankly, companies think about their risk. And if they think the risk is maybe of that list of 1,000 GPL violations, maybe we get a call from somebody enforcing the GPL. There's only 10 or 15 people total in the world enforcing the GPL. What are the odds we're going to get called by one of them? And all we have to do is release the source code when we get a call. So let's not even bother with releasing the source code now. If we happen to get a call, I guess then we'll release it. Otherwise, we'll do the product. Most electronics products last most 3 years in the market. And then the product's gone, and if we haven't gotten to them in 3 years, they're on to the next product, and we have to find out if that one's violating the GPL. So it became clear that we would have to file lawsuits. I was fortunately at the time working closely with two attorneys named Dan Ravisher and Aaron Williamson, and we filed a number of lawsuits in the US. Now, most of those lawsuits you'll see were settled rather than going to a jury trial as we have in the US, or to the end of the court process, generally speaking. And the reason we try to settle is because what we want is compliance. We don't actually want money in an injunction, which is what courts typically give us. So our goal is to use the leverage of the lawsuit to say, look, your product's filled with GPL and LGPL stuff. Just comply on everything. And that was important. We felt like if we're going to enforce in BusyBox, we want them to also comply on Linux and FFmpeg and any other project that they use. We want to make sure they're complying on those too. So even though we're focusing on BusyBox as our main enforcement, we think you ought to comply on Linux and everything else. And if you'll comply on everything, we'll drop the lawsuit completely. And we know that the judge is unlikely to grant us release of source code. So if we can get them to release the source code, we're happy to settle the lawsuit and end it right there. And that's why you'll see so many of these lawsuits actually settle rather than going to the end of the process, although I'll talk in a few minutes about why we're going to have to go to the end of the court process in many jurisdictions soon. We're going to have to start doing it soon, and it will take a long time. So the big lawsuit we filed, the largest GPL enforcement lawsuit ever filed in history, was Software Freedom Conservancy, et al., where I work, along with Eric Anderson, and then versus Best Buy et al., and that's et al. Because there's 17 defendants. And we settled with almost all of them. They came into compliance not just on BusyBox, but on Linux too. Although we, again, had this problem where there was occasionally a Linux proprietary kernel module. And since we were enforcing on BusyBox, we sometimes settled allowing them to keep that proprietary Linux module because our lawyers told us, well, you're not a copyright holder on Linux right now, and that's much harder to get them to comply on that. And they're complying on BusyBox now. So we've had to settle, and I'm going to talk more in a few minutes on that. In the one case we didn't actually settle, we received what's called a default judgment. In the US, a default judgment means that the person you're suing basically stopped defending themselves. They just ceased to exist. And in this case, this company went bankrupt. And it was kind of fun. I was there the day that the judge read off. This is Judge Shinlin from New York. It's a U.S. federal court, which means it's at the entire U.S. level. But they have district courts in every region. And this is the Southern District of New York, where she's based. She actually became world famous because, I don't know if you know this, there was I know there are people who are into privacy rights and so forth. There was this rule in New York City that you could stop people on the street and just search them, which is illegal in the US, and she was the judge that ended up deciding that that was illegal and that the police couldn't do that anymore in the US. So years after our lawsuit, she was in the newspaper. I was like, I know who she is. I was in her courtroom, and she's now world famous because she stopped New York City from doing what's called stop and frisk. But I was there the day she read out the decision of our default judgment. This was an amusing phrase she said as she was reading it out. She said, they're still producing these busy boxes. And she made it plural, which is weird because BusyBox is not plural. But she was thinking of this, this is a children's toy that Eric Anderson and actually Bruce Perrins, who started the BusyBox project, named it after. He had young children at the time. And it's called a BusyBox because there's a little boxes of things that kids can keep themselves busy with. And the idea was, well, BusyBox does all the different Unix utilities all at once, so it's like one of these things. There's a little area that has each Unix utility in it. But she surely knew what this was, but she had never heard of it as the software, so she was thinking of them in her mind together. But she did some cool things. She did grant us one of those injunctions, like I talked about. And in fact, one of the things you get in a US court when you get a decision in your favor about copyright infringement is you can demand a destruction of the infringing articles. And actually I had, because I care about other moral issues other than software freedom, I had a real environmental concern about this idea of destroying TVs. Like these are electronics devices. They're going to end up on the coast of India or somewhere else where people have to take them apart. And so we should get some use out of them rather than just putting them in a landfill or something. So we actually asked for them to be donated to charity as a resolution. I was concerned about the idea of having GPL violating devices given to charities, but on the other hand, I didn't want to see them in a landfill. So I suggested to our lawyers that we do that, and so we did. And now a funny thing happened that the lawyers on the other side, of course, they said, well, Westinghouse is bankrupt. We can't possibly continue being their lawyers because there's this duty in the United States. It's called a duty of zealous representation that lawyers have for their clients. So even if your client's not paying you, if you've already engaged in a lawsuit defending them, the judge has to give you permission to stop defending them. You can't just walk away. You have to have permission because you have this duty as a lawyer in the US. And so the judge granted them, in the same ruling, she granted them permission to not be the lawyers anymore. But here's a funny thing that happens. This is how corrupt the world is, how corrupt the US is, and basically how nasty GPL violators can be. So we walk out of the court with this decision. We think, this is great. We've got this judgment. And then we find out that because Westinghouse was incorporated in California, of course, they sold products over the US, so we were legally allowed to sue them in New York. They went in the same day into a California court and used this weird bankruptcy rule in California. In California, your company can go business on a Friday. You don't have to lose the assets, though, that you have left. You can transfer those to another company on a Saturday, right after going bankrupt. Then that company can go back into business with a similar name on a Monday. And as long as the management is not the same as the previous company, it's legal. So in this case, the brother of the guy who was the CEO of the old Westinghouse became the CEO of the new Westinghouse. And they went back, and then he hired his brother for a non-management role. So this is the kind of nasty things that they do. And they have this new lawyer, right, who knows nothing about the case. He actually wasn't a very good lawyer. And we go into court to have a hearing about this to add them to the lawsuit. And we're having a fight with them. And who shows up but that lawyer who had begged the judge to be off the case is sitting with me in the gallery. I'm sitting in like the gallery area where just observers can watch the court proceedings. He's sitting there giving hand signals to the other lawyer. At one point, he even shouted out what he should do across the room and said, no, do that. So it's like this lawyer who was saying, oh, my client's gone, Your Honor. I can't defend them anymore. They're not paying my bills. But I'm going to show up when we get the new lawyer for the new company and just happen to be in the courtroom. This is just bizarre, right? I mean, the judge is seeing this, and there's nothing she can do. It's a California rule. There's a California state rule. She's a federal judge in New York. It just shows how corrupt the system is. And this is why if you hear me sort of talk about this idea that GPL violators, they're not just people making simple mistakes. I used to say that. It used to be the case that most GPL violators they were just made an innocent mistake, didn't understand. They actually wanted to join the free software community. And it's certainly true that that continues. There's kind of an eternal September. Those of you who are older remember that concept from Usenet. There is that in the GPL world, right? There's always new companies, new adopters showing up for using Linux, and they don't understand, and they need to be educated. And I think it's important to educate them and help them understand the GPL is not scary. It's pretty easy to comply with. You just release the source code. It's not that hard. If you're working upstream, you're probably already in compliance anyway, et cetera. But we've solved those kind of violations for many years. The problem is we have a lot of violators now who have hired lawyers that know who I am. They know this whole space. They've read the GPL many times, and they're advising their clients, hey, you can keep some of your stuff proprietary. You can get away with it. Because look how hard it is for them to enforce the GPL. Look how much work they have to do. They have to go to court. They're a small organization. They don't have a lot of resources. It's expensive to go to court. So you can kind of get away with doing this. We now have these opponents who are experienced, they're wily, and they've decided to see if they can get away with violating the GPL, and they're sneaky. We as a community try to operate very transparently, try to be honest, try to be open about what the work we're doing, which means we're always at a disadvantage because we're honest and they're not, and we're straightforward and talk about what we do. I'm sure there's a GPL violator online or at some point later who will watch this video, hello, and I may be presented with this video in a deposition in some future court case and asked about every little thing I say. If you notice, I'm very careful at choosing my words. It's because I'm always thinking that years later, I'm going to have to hear these words again in some GPL enforcement case, right? This is the kind of things they do, and I want to be open with our community and explain what we're doing, but they're not going to play the game the same way. I still do it because I think we should not just win, we should win in the right way. We should win in a way that's moral and correct rather than just winning for winning's sake, which is a lot of times what, unfortunately, the way lawyers think. So the last part of my talk before I go to questions here, I want to talk about sort of how we ended up doing enforcement for Linux at Conservancy and how that all worked out. So as I mentioned, we were mostly doing BusyBox enforcement, but we were asking for people to comply with Linux. So even though we were just enforcing for BusyBox, we'd request they'd also come into compliance with Linux as well. Now I actually had talked with Harold about this. I mean, we both, Harold and I, felt this was a relatively reasonable thing to do to make sure that the product was in compliance fully rather than having everybody have to go do their own enforcement. Each project that's GPL would have to do their own enforcement. Whereas the one project who happens to be doing a specific enforcement could make sure everything was in compliance. Now the problem is that there was disagreement in the even in the Linux community about whether GPL should be enforced. There are Linux developers who believe the GPL should never be enforced. That's their view, and it's in fact their right. As a copyright holder, you're not required to enforce the GPL if you license your copyrights under the GPL. It's your option, each copyright holder, to decide if you'd like to. What happened was GPL violators, they're smart, and they discovered this was a political weak spot. And they in fact started to plant ideas and people in our community to create political disruption and complain about Conservancy's enforcement and Conservancy asking for compliance on Linux. And in fact, if you go read this, I titled this slide, Tempest in a Toy Box. That's the name of a Linux Weekly news article that discussed our enforcement. If you go into the comments, and there's links there, you've got people who are accusing Conservancy of violating the law by asking for this. Of course, we knew we weren't violating the law. You're allowed in the US to ask for anything you want in a settlement negotiation. And one of the things we asked for was compliance with Linux, and it's completely reasonable to ask for that. But people are saying that, oh, they're doing what's called copyright abuse, which is a criminal offense, and so forth. And so there was really kind of a push to discredit our work. And even though we were legally sound in what we were doing, it was very clear. These days, I'm kind of a free software politician, reluctantly so, but I admit that I'm somewhat of a politician. And it became clear to me as a politician that it was now politically unviable to do enforcement this way, to enforce on BusyBox while asking for Linux compliance. And since so many companies involved in Linux, even ones who contribute to Linux, would rather see the GPL never enforced, there was just too much political opposition. And they really wanted to kind of shut down BusyBox. There were efforts to rewrite BusyBox. Toybox is one of them. They recruited a former BusyBox developer to do it and denounce the BusyBox enforcement, all sorts of political maneuvers. And what I really felt we had to do was stop asking for Linux compliance through BusyBox enforcement, because that's what they were insisting we do. So we actually got communication from industry consortiums and trade associations that claim to represent Linux and saying that you don't have a right, we represent Linux, you don't. We don't want you to ever ask for Linux compliance again. Now, what happened was lots of community developers were following this. There's names of a few of them on the slide there, had been asking me to enforce their copyrights anyway. And Matthew Garrett in particular and others had said, why don't you just enforce for me? I want to see the GPL enforced, so go out and enforce for me instead. So Conservancy established a project, another of our member projects, that's focused on doing enforcement for people who hold copyright in Linux. If you hold any copyright in Linux or Samba or many of the other projects we enforce on, you can sign an agreement with Conservancy and we'll enforce the GPL on your behalf. And this was our political maneuver to respond. Basically, once we had Linux copyright holders working with us, there was no validity to their complaints. I don't think their complaints were valid in the first place, but now even their core argument, which was we didn't represent the Linux community, was false. We had the Linux developers who wanted to enforce the GPL were working with us. We have more than a dozen of these copyright holders working with us now and doing Linux enforcement. The reason I feel that we have to do it, we have to enforce on Linux, is because this is where the opposition has decided to take their stand. They've decided they're going to fight the GPL on the front of Linux because Linux is the one program that companies don't want to rewrite from scratch. Some of them have adopted BSD, some of them have adopted other kernels. Apple famously uses the BSD kernel in part because they hate GPL. Not the only reason, but that's among their reasons. And corporate lawyers have said, well, look, let's just fight this. We'll keep making proprietary Linux modules. Eventually, we'll build a system whereby the GPL is not really the GPL anymore. It's more like the LGPL. That's kind of their goal. And that's why our focus now is around the issue of proprietary kernel modules and proprietary modifications to Linux. Lots of people debate this topic. You'll find any mailing list that has a bunch of lawyers or policy people from free software. They're debating, what does it mean to make a combined work of Linux? What does it mean to make a Linux module? Certainly in my work, I have been around lawyers enough that I focus on fact patterns. This is the way lawyers think. They want to see an exact set of facts and then analyze how the law applies to those facts. And I've looked at many of these regarding Linux modules. I have yet to be presented with a fact pattern of a Linux kernel module that was not a derivative work of the combined whole of Linux. If you have a .ko file, every time I've been shown a .ko file and analyzed it in the context of Linux, I've come to the conclusion with lawyers, advice of lawyers, that it is a combined work with Linux. They're working on the other side to figure out how to make arguments in court to stop that, and they're getting ready for a fight, and we're going to have to bring them one. It's an accident of history in some sense. It's weird. We would have thought, back when I worked for the FSF, I would have thought eventually GCC or some FSF program is going to be the center of the fight of GPL, because FSF is the organization behind the GPL and many of the early programs that were under the GPL. But because Linux is a great program that people don't want to give up and don't want to rewrite, it turns out that's where we're going to have the battleground for Copyleft. It's a zero-sum game, ultimately. If we win, we liberate software that was supposed to be under its license liberated. If they win, they get to proprietarize Linux. And so people have accused me of being aggressive, accused me of I think I recently said I was creating a somebody said I was creating a circular firing squad in the free software community, whatever that means. But the reason we have to be aggressive and face this is we're diametrically opposed. They want Linux to be proprietarized. We want Linux to be free software. There's no way we can just sit down and talk that out. We're going to have court cases. We're going to have to test this issue of what is a combined work of Linux. We've begun this work. Last year, early last year in 2015, we filed a court case. We funded a court case by Christoph Hellwig in Germany against VMware. Now, it turns out we were reported a violation in 2011 that VMware was violating the GPL. When we looked back, we discovered that it had been going on since 2007. We received for the ESXi 5 product from VMware that they were violating on both BusyBox and Linux. They actually did a lot of good work to fix their compliance problems with BusyBox and even a number of other GPL programs. But they absolutely refused to come into compliance for Linux. They would not comply with the GPL on Linux. And we ultimately worked with Christoph to sue them in Germany. Christoph is one of the main copyright holders in the parts of Linux that VMware is incorporated. I'm going to talk about that a little more. Now, the way court cases work in Germany, their court proceedings in civil cases are private, not public. So it's limited amount that Christoph's allowed to say. There's actually legal rules about what he's allowed to say in public. And we have been able to publish as much as we can. We have an FAQ that's linked to there on our website. But here's the basics of what VMware did. So on the left here is a picture of what kind of Linux looks like internally. That's in the internals of Linux, roughly speaking. And you see that inside Linux, there's this whole SCSI subsystem that Christoph developed. There's the radix tree that he developed. He developed a bunch of the SCSI drivers. So that's where Christoph's code is. And there's also there a lot of networking code, a lot of networking drivers. Well, what VMware did is they started writing a hypervisor for their virtualization architecture. And it turns out in the mid-2000s. And they were lazy. They basically said, well, you know what? SCSI code is hard to write and difficult and complicated. Let's not write our own. Let's just steal Linux's, put it in our product. And right in here, you see inside VMware's kernel, they've got Linux, they've got Christoph's SCSI subsystem, they got his radix tree code, they've got a bunch of his drivers, and they also took all the USB drivers and all the USB subsystem and the networking drivers and networking subsystem. If you rip all this code out of VMware and you boot their product, it just sits there and stares at you. It can't talk to the network, it can't talk to a disk, it can't talk to a USB device because they took all that code from Linux and just put it into their kernel. Now they argue in court, you won't be surprised, that this line here makes a separate work, they claim, that this here is a separate work from this, and that all of it's a separate work from the whole of their kernel. Our view is that this is one work under copyright. Just like it's one work over here in Linux, our view, it's one work over here in VMware. And they're arguing against that. So it's ultimately a legal question. We're down to the legal question of what is a combined work with Linux software, or with GPL software. And that's where we knew the fight would always be, and we decided to do it in Germany in part because of Harold's work previously there. Now, Germany is not a precedent system, it's not a common law system. I don't think you're a common law system here either. But yeah, it's not a precedent system, but the expertise in Germany is there. Particularly a lawyer named Till Jaeger. He's probably one of the most prominent GPL enforcement lawyers in the world. He was Harold Velta's lawyer for all his cases, and he is operating as Christoph's lawyer. We made a grant to Christoph, so we're funding the lawsuit, but we're not a party to it at Conservancy. It's Christoph's copyrights and Christoph's lawsuit, and we're just advising, and I've helped a good deal. I really wish I could say more about what's going on. It's unfortunate that it's unfortunate to me. I admit a certain US legal system bias. I grew up with the idea that all court proceedings are public. You can go online and read everything about what's happening in court, be it a criminal or civil matter. That's how we are in the US. The British system is similar. But in Germany, that's not how it works. It's a different system. But it also means that I can only say so much. There are 2 blog posts you can read. Harold Velta actually was allowed to go to one of the hearings in this case, and he wrote a very interesting blog post about it. And I followed up with my own of what I knew about it and what I was able to say. We just filed another round of documents in this case. I helped as a technical, I advised the lawyers on some technical details and wrote a technical report for them that they incorporated parts of into their filings. So that's where we're at with that lawsuit, but we're probably gonna have to bring more. This is unfortunately the only way to make the GPL work at this point, because there are people who want it not to work. I think that wasn't the case in the past. It used to be that the GPL was something we all kind of agreed was okay and would work. Now there's multiple camps. People want to see the GPL fail because they want to make proprietary works of Linux. Now, I talked a lot about how I'm very troubled by some of the ways that the GPL has been used. I'm embarrassed, in fact, as someone who's worked on GPL and helped write the Affero GPL, which is also used in this way. I'm troubled by it. And I think that centers down to the question of avarice. It centers into, if you're trying to make money more than you're trying to help the world, you're going to be corrupt. And I've been given a lot, if you look on some of the LWN discussions about our work, they sort of say, well, why don't they make the violators just give them a lot of money instead of asking for the public to donate to Conservancy to fund lawsuits? Well, I've been offered that choice plenty of times. The first thing a GPL violator always says to us is, how much can we pay you to not have to follow the GPL? One of our lawyers once said to us that they liked having us as a client because if we're out in a boat in the rapids and we're about to die and somebody comes in with a helicopter and offers us $1 million check and a promise to take us out of the river or the water on a helicopter and we'll be safe, we'll still say no. And that's how we think, right? You can't buy your way out of the GPL. You can't give $1 million to Conservancy for me to look the other way from a GPL violation, or $1 billion. It doesn't matter. Now, once we say that, the problem is we say, because from my point of view, once you take any money without full compliance, like to be clear, we take usually recovery of our costs after the suit is over. But if you take money before compliance is achieved, you're basically selling them a non-GPL license. You have to achieve full compliance with the GPL first before you have a discussion about reimbursement of costs and those sorts of things. Because if you take the money first, you're basically in MySQL's business at that point. You're offering a proprietary license. And what happens is, because we spend so much time on these 26 CCS checks and so forth, they offer us less and less money as time goes on because they spend money on their side for their own lawyers and so forth and their own technical experts. And so by the end of it, the money that they're willing to give us for the enforcement action is much smaller than that first number they offered us to just make us go away. And at that point, we have compliance. So we're not going to demand, demand unreasonable amounts of money because we've gotten the most important thing, the one that really matters, is that they're complying with the GPL. So from that point of view, ultimately, our GPL enforcement efforts at Conservancy are funded from donations from the public around the world. And the reason we do that is so that we can be sure we follow our principles. I want to be answerable to you as a public. I want to be answerable to the people that donate to us individually at $120 US per year, instead of being answerable to somebody who gives me a huge check. I don't want that to be what controls my work. That's why I work for what's called a 501c3 public charity in the US. In the US, we're actually legally required as an organization to act in the public good. That's a requirement of our status of filing as a corporation in the United States. And you can donate. I'm sorry to end with a fundraising pitch, but Karen Sandlin, who I work with, our executive director, reminds me we should do this, that you can donate to help us. Here are a couple links to resources. The key ones I want to point out is I've written, or actually I've pulled together from various sources, including some of my own and others that other people have written, this thing called the Comprehensive Guide to Copyleft and the GPL. And that's a copylefted work itself. It's under the Creative Commons share-alike attribution license. CC by SA, and you can contribute to that. And there's lots to do. A lot of it is, some of it's just reorganizing text, and it needs to be integrated better. It's from various different sources. So even if you don't know much about copyleft, you can contribute to make documentation on understanding copyleft better. I have a podcast which somebody here's already asked me about. We're going to get it going again with my colleague Karen Sandler at Conservancy. It's called Free as in Freedom, FIF.us. We have a couple, I think almost 100 episodes past that you can listen to from before about all sorts of policy and legal issues in free software. And then we're going to get started again in a few months. So watch that link. There's an RSS feed there. And the slides for the talk are online and so forth. And with that, I just want to open up for questions.
Give us a minute to recover.
OK, sorry. So I hope I didn't talk too fast. Traditionally, I talk very fast, but when I'm speaking to a non-native English-speaking audience, I do try to slow down. Hopefully I did.
I think the speed was OK.
Thanks.
More a comment more than anything else.
Sorry?
This is more of a comment than a question.
Yeah.
At the beginning of this talk, I was like, OK, he's going to talk lawyer talk, so I'm not sure I'm going to understand half of what you said, but I'm OK. And I feel very smarter now about licensing and the discussions that's going on. So thank you for that.
You're welcome.
Not sure how it will apply for my life. And don't ever be embarrassed about having to end with a pitch for money because, well, all of us know
Yeah. Thank you.
that money costs, food costs, lawyer time costs.
Yeah.
So
I think one of the things that one of the problems with lawyers, generally speaking, are that they act like law school is Hogwarts or something, like that there's some magic to being a lawyer, and in fact there's not. I mean, the only thing you can't do if you're not a lawyer is represent a client as a lawyer. But the concepts, I think anybody who's reasonably intelligent can understand. There's a lot to learn, and I've spent years as a software developer learning from lawyers about legal concepts. But it's very different than the way software works. But it's not hard to understand. It just requires background knowledge that you have to read about. So you shouldn't feel worried that you can't understand legal concepts. They want you to think you can't understand them, but it's just like any other field, like history or any science field. You just learn the background, and then eventually you can be part of the discussion. So lawyers want to pretend like they have special magical skills, but they don't. They're just people who read a lot of things, and you just read the same things, and you know as much as they do.
This is probably more of a technical question, which I probably find online. But let's suppose I'm Apple and I create Objective-D, which I will only use for internal use. And it's a proprietary front-end for GCC. I write code, which is again closed source, and then release it. Not the code, but the binaries.
Mm-hmm.
Are they, like, is there a GPL violation there?
So the GPL triggers, the copyleft portions of GPL trigger on the act of distribution of the software. So when you distribute the software, you are then required to give the complete corresponding source code to the person you distribute to. So if you never, I'm going to get to your specifics in a minute, but in the general sense, if you never distribute the software, then you never have that obligation under GPL because you've never given it to anyone, so you have no one to whom you owe source code. The license called the Affero GPL, which I helped design, is actually designed to expand copyleft into the network services space. So what the Affero GPL says that when you deploy a modified version of the software on a computer network, the users of that software who have access to it on the computer network have a right to ask for and receive source code. So that's a different license. It's not the GPL, it's the Affero GPL. It's an extended version of the GPL. And GCC is not under the Affero GPL, it's under the regular GPL. So if they write, if some company writes a proprietary front end to GCC, never distributes the result, they generally don't have to distribute the source code for that. Now, you asked a specific question about the binaries they produce, right? So they've now written a proprietary or a proprietarized compiler that they've never distributed, and they're producing binaries with that. Now, this was a decision that people thought a lot about with regard to GCC because they wanted to prevent certain amounts of proprietary plugins. So this is where it gets to a very complex topic. Because the fear that someone would do that with GCC was very real and palatable, particularly when the switch to GPLv3 happened and GCC started to build a plugin architecture. The concern there was not exactly a front end, but the fear that someone would take GCC, modify it, and write out its internal representation, and then write a proprietary program, which is a separate work, that read in those files, ran the proprietary operation, wrote out those files. And then somehow was able to use GCC again as the back end to generate the final executable code, right? And this will be like a workaround to the GPL because you've written this separate work over here. All it does in reads and writes files. It's kind of like the MySQL. I guess MySQL AB would say that's derivative work, but I would not. I would say that if it's a separate program over here that just reads and writes some files in a particular format and doesn't combine in any GPL code, it's probably not a derivative work. So the fear of that led to creation of what's called the GCC Runtime Library Exception version 3. That is a very complex, I helped design it. It's a very complex exception to the GPL. And what it does, you're probably not going to understand much of this, so I'll give you a flavor of it and you can go read about it because it's so complicated. But the basic idea is this. When you compile a program with GCC, actually any compiler does this, parts of the compiler's code are actually copied into the output, because you usually need the bootstrapping code and other types of things that are from the compiler for it to work. Historically, so that you were allowed to compile non-GPL software with GCC, there's a thing called the runtime library exception that has historically always been in GCC to make sure when you produce the binaries produced by GCC, just from your own code input to GCC, output to a binary file, are not covered by the GPL. So that's always been the case. But as a mechanism to prevent basically what you're talking about, a proprietary plugin that you keep private or anything like that, we wrote this thing, I helped write, the FSF write it, called the Runtime Library Exception version 3, which actually says this weird thing where if you choose to do what you're talking about, or do this other thing I was talking about over here with a third-party program or a separate program to add optimizations, if you do that, your runtime library exception evaporates, which means that you have to make all the output from the compiler be GPL'd. So it's this weird ironic outcome, which is you can do what you're talking about, but all of your programs you compile with have to be GPL'd. Which, of course, that nobody wants to do. So they say, well, I guess I won't do that, because if I do that, my compiler is now useless from my point of view, because I can't compile proprietary software with it. It's a really complicated licensing structure, but it gets the policy goal. It's kind of the most complex copyleft mechanism ever invented, and it's a little too clever for its own good in some sense, because it's very difficult to explain. But that's the basic flavor of it. I wrote a blog post when it was announced about just search on my blog for runtime library exception. It's a very long blog post that explains how it works, and that's probably a better resource than just trying to answer it as a Q&A, because it's complicated. But that's the basic idea of what was done with GCC to prevent what you're talking about. Yeah?
Do you have any views on this Google Oracle case?
So I've written a lot about it on my personal blog. There's so many aspects to it. I'm going to ask you to give me a more specific question you're interested in, because there's so many aspects to that case that there's probably 100 different things you could be asking about.
Please rephrase.
I will. They're asking about Oracle v. Google, but I'm asking for more specifics now anyway. So, yeah. So what would you like to know? Okay. Oh no, is there a specific part of the case, the Oracle v. Google case, that you're interested in? Yeah, I could give you 30 minutes on the various stuff about Oracle v. Google that matter, but I don't know if anybody else wants to hear that. So think for a minute if there's something more specific about the case you want to ask about that I could answer a little more succinctly. And I'll take another question in the meantime. I'll come back to you. You have more questions?
I kind of the same kind of question, but it also actually involves Oracle. It's the ZFS inclusion in Debian
So since you asked about ZFS, I'll talk about it. Now, first of all, there's links here to both Conservancy and FSF wrote a statement about the situation, which I encourage you to read. That's important. But one of the reasons that, so the important thing to note is that ZFS is free software. It's under a free software license called the CDDL, which was published by Sun, now under the control of Oracle, because Oracle bought Sun. And the reason why it's being taken so seriously in our community is because when you look at the legal question of, if I have a kernel module, in this case ZFS.ko, sorry, I'm a US person, I say Z instead of Z, .ko, and you combine that with Linux, what is the legal outcome, right? That's the question, given that the license CDDL is incompatible with the GPL. That legal question is more or less the same question as, I have a proprietary license .ko file under some evil NDA, and I combine it with Linux. So we have to take it seriously. Even though, and there's a section in Conservancy's statement that I wrote, that particular section, where we talk about how painful it is to feel so close to having the ability to incorporate ZFS and Linux, and that as a technical matter, I feel that pain. I think ZFS is an interesting technology, and it would be nice, technically speaking, to be able to combine it. But because of that legal question being the same, it's dangerous. So if we tolerate CDDL-only modules as combinations with Linux, if we say, oh, that's OK, which I think it's not, unfortunately, because of the way copyright rules work, it would just be the same as tolerating proprietary Linux modules, which is a problem. And in fact, the people that I was talking about before who really want to encourage the idea of allowing proprietary modules for Linux, they're very interested in what's happening with ZFS, because if ZFS on Linux is allowed to be something that companies can sell and so forth, if Canonical can go in the business of selling it and get away with it as a GPL violation, then they'll say, well, that's allowed, so what I'm doing should be allowed too. There's no legal difference. And I think that would be a persuasive argument to a court if we allowed it, which is why it's not allowed. I think we just have to take the clear stand that copyright law gives us, which is a permission-based system. Anytime you have a work under copyright, you need permission to do the things that copyright law governs, mainly copying, modifying, and distributing the software that's under copyright. So given that, you need permission from somebody, actually from a lot of somebodies, to combine ZFS.ko and Linux. To do that, you need permission. You need permission from the people who hold copyright on Linux. You need permission from the people who hold copyright on ZFS. Now, the ZFS developers, Oracle in particular, which is the major copyright holder of ZFS, or ZFS, they hold copyright. They chose to license their copyrights under CDDL. They chose to draft CDDL specifically. In fact, Oracle, or Sun at the time, wrote CDDL with the goal of making it incompatible with GPL. The reason they did that is because they had to please the Solaris engineers who wanted Solaris to survive. So they were like, if we're going to open source Solaris, we want to make sure that the Linux people just don't take Solaris and put it in Linux. So we want to put it under a non-GPL compatible license so that people will adopt Open Solaris instead of adopting Linux. Right? That was a strategy goal that Sun had. So we know from history that they specifically wanted CDDL to be incompatible. There's no confusion about that. It is a separate license which gives a separate set of permissions which are not the same permissions that GPL gives you. So if you combine the two, you're infringing copyright. You're infringing the ZFS copyrights because CDDL doesn't allow you to combine GPL works with CDDL. You're infringing the Linux copyrights because GPL doesn't allow you to combine CDDL software. So you can't do it. It's not permitted under copyright law. It's a copyright infringing act to distribute ZFS.ko, period. And I wish we could get another outcome. We've called on Oracle. Canonical has agreed that this is the right thing to do, to call on Oracle to relicense those copyrights. They could do it. They could make one statement. They have two ways they could do it. One, they could say we grant permissions separately and additionally, like I talked about with what MySQL does, to license our ZFS copyrights under GPL. So it's still under CDDL, but we grant you an additional license under GPLv2. They could do that. They're also the stewards of CDDL. So they can publish an updated CDDL that says, from now on, you are allowed to combine works under CDDL with GPLv2, and we permit that. So Oracle has two different ways they could do it. And the second way would solve the problem in one step. The first way, then the other ZFS copyright holders who've contributed since they forked it from Oracle would also have to relicense, but there's only about 12 of people that we actually have to get to do that. And it could all be done, and it could all be solved. And it's Oracle that's doing this to us, and they like the fact that they're doing this because they want to disrupt the Linux community for their own reasons. And so we should really think about who the real enemy here is, and it's Oracle. Go ahead. Oh, interesting. I'll repeat it in a second.
But if I understand correctly, the first thing blocking here is the incompatible license. So you haven't really looked at the patent side yet?
I haven't looked. So the question is about, well, aren't there also patents that read probably Oracle patents now that read on ZFS? And therefore, even if you have copyright permission, you might have a patent problem. That's probably correct. I don't know any, I've never analyzed the patent situation. I really try to avoid analyzing patent situations if I can help it. But you're absolutely correct that software is kind of this weird thing. There's not many endeavors in human intellectual work that are simultaneously covered by two basically incompatible legal systems, right? So software is simultaneously governed by copyright and patent. So you can have a copyright permission, but then there's some patent you don't know about that reads on your software, or you could have a patent license to do something, but then you're infringing copyright. So you actually kind of have to check both at some times, and that's this point that you're making here, which I think is correct, that we have this copyright problem because of the CDDL GPL incompatibility. We could resolve that, and it could turn out that Oracle has some patent, and they're actually secretly waiting to try and enforce it. Now, this actually could relate, and here's why. Because most people believe GPLv2 has a pretty strong patent provision. It has this thing called the GPLv3 patent provisions are even stronger and more detailed. But in GPLv2, in Section 7, it says that there are certain rules about what you can do with patent licensing. If you choose to license something under GPL. So it actually could be the case. One of the reasons Oracle refuses to license under GPL is because they don't want GPLv2 Section 7 to apply and therefore somehow impact their patent holdings. Could be. Oracle hasn't thought that deeply about it. I think their decision is, hey, look, all the Linux people, they're all confused and don't know what to do. That's great for us. We love when Linux people are confused because it helps us sell unbreakable Linux and our products that are based around Linux, because then, well, if you come to Oracle, we'll make everything right, and you want Linux from us, not from Red Hat, right? That's kind of what Oracle's trying to do. So that's great for them in that regard. And I also want to point out that I've been laughed at by a lot of BSD people because they don't have the licensing compatibility. That's a matter of fact, right? If you want to run ZFS on OpenBSD, FreeBSD, as far as I know, I haven't done a deep analysis, but the BSD licenses are completely compatible with the CDDL. The CDDL may end up governing more of your kernel than you like. It could be the case because it is a weak copyleft, so there is a copyleft effect. But you're certainly permitted to use ZFS. And I actually have told the BSD people, just get out there and market yourselves as the solution for ZFS, right? I mean, if it turns out that people don't use Linux because they want ZFS and they use BSD, I don't mind if the BSDs become popular because of that. It seems okay to me. And also, I think that on another point with the BSD community, I think we all could agree that maybe Oracle shouldn't license it under GPL. Maybe they should just put the BSD license on ZFS, and then we can all use it, and it can go into Linux, it can go into BSD, upstream, mainline. Why not ask for that? And I've encouraged BSD developers to work with us on calling on Oracle to put it under the BSD license and just be done with it. I think it's difficult to get Oracle to do anything, and it's going to take a lot of pressure, but I mean, years of community pressure might be successful. Sorry, you had a question that I cut you off before.
You mentioned Unbreakable Linux. Does that have ZFS?
No, it does not. I've checked. You got it. You got it. They're smart enough not to do that, as it turns out. And they don't really have an interest, I think. I mean, this is just my armchair industry analysis, but I don't really think they have an interest in selling ZFS for Linux. If they did, they would have done something different here. They probably would just put it under GPL if they really had an interest. I think that it's the Solaris people inside Oracle that are trying to market ZFS, and I think they want to keep it for themselves and try to save Solaris, right? There's still people who work for Oracle that believe Solaris is going to come back soon, you know? And there is, because they do have, and in fact, I've been told by Oracle people that they've continued to develop ZFS as a proprietary product. So if you buy Solaris today, you get a version of ZFS that is different from the one that's out there under the CDDL. So they've continued on developing it as a separate thing, and they have new features and so forth that you can buy from them. So they're focused on selling that as a Solaris product. So I don't think I think this is a hard ask for various reasons, but I think they should do it because it's right. But lots of companies don't do what's right, they do what makes them money. So. Another question besides ZFS? Even if it's about ZFS, that's okay.
Yeah, it's a GPL question.
Yeah.
So I'm a big fan of GPL, so I've been using it since the 90s for everything.
Mm-hmm.
And then version 3 came and complicated things a bit, because then you got these two camps that is GPL2 only, and then you have those from GPL3 and onwards, and then you have. I'm licensing all my stuff under GPL2 or later.
Mm-hmm. Mm-hmm.
So, are there any complications by doing that? For example, will someone can take the code, make some extensions to it, and under the GPL3, and then I won't be able to put it back into the GPL2 or later?
So the question, to repeat the question for the recording, the question is about the GPL, releasing things under GPLv2 or later, and the question is, does that allow people to fork it under GPLv3, and would it mean that the patches and changes can't come back to the GPLv2 or later question? And the more general question was, there's now licensing compatibility within the GPL world because of GPLv2 only and GPLv3 or later. And the answer to both questions is yes, the simple answer. To your second question first, when you put it under GPLv2 or later, which I think is a fine idea and reasonable solution in your case, certainly people are allowed to change to GPLv3 if they want to, and make it GPLv3 or later, or even make it GPLv3 only, or make it GPLv2 only. All of those options are possible when you give something under GPLv2 or later as your license. I think as a social matter, I think it's very easy to convince people, gee, my original project was V2 or only, V2 or later. Could you please give the patches back? I would be surprised if there were people who are really out there trying to thwart you by doing that. The question of the incompatibility, the GPLv2 only, I find it bizarre that people are angry about that because if you analyze it, it's actually an outcome of the FSF as a license steward for GPL being nicer than other license stewards. So if you look at every other license, other Copyleft license at least, the Eclipse public license, the Mozilla public license, they all give the license, and the CDDL, as I was just talking about from Oracle, all of those licenses give the license steward, the original publisher of the license, authority with or later. I.e., you can't choose Mozilla public license version 1.1 only. It's impossible. Because the Mozilla public license by default says that if you choose the Mozilla public license, or you choose CDDL, or you choose the Eclipse public license, you are granting the steward of the license, be the Mozilla Foundation, the Eclipse Foundation, or Oracle, permission to relicense your work unilaterally if they choose to update the license. I think actually GPL was nicer to developers in some sense. It said to developers, you see the text of GPLv2. You like it. If you want to, you can say GPLv2 only. If you don't really trust what the FSF's going to do next, and many people didn't, which is fine, You don't have to trust, you shouldn't trust people implicitly. People said, I want to do V2 only because, and Linus Torvalds is one of them. He said, I like V2. I don't want the FSF to change my license, so I'm going to do V2 only. And those same people who did that, like people who changed the BusyBox project from V2 or later to V2 only, are now saying, well, it's all the FSF's fault for publishing a new license. Well, no, it's not. It's the blame lies with people who went V2 only. I think it was a reasonable choice to go V2 only, even though it complicates the world. Because I think people should have a right to choose their own license, their own version of the GPL that they like for their code. And if they only like V2, it's okay from my point of view if they choose V2 only. There are consequences of that, namely that it makes combination with V3 or later works difficult. But it's a choice that each developer has to make for themselves. Now, if unfortunately the sort of issues of this problem were not fully understood when V2 was published. V3 has a very good clause in it, which I wish were in V2, but it's not because we'd have to go back in time to put it there. But it says that you can name a proxy who is the person you trust to decide about future versions. So you can actually choose something GPLv3 only. And so imagine if Linux was getting started today. What Linus could do when he started Linux is instead of choosing V2 only, he might choose V3 only. And he could say, I'm naming myself as the person to decide if GPLv4 can be applied. So that way you don't have to go to every copyright holder. We could, in fact, relicense Linux under V2 or later. We could do so by asking every single copyright holder to agree. And I've actually done work like that. I helped the Squeak project relicense from a non-commercial only use license to a BSD license because they didn't want to be a non-free software license anymore. They wanted to be a fully free software project. And so the Conservancy helped them relicense under a free software license, and it required a year-long process of contacting every copyright holder. Another example of this is VLC. They chose to relicense parts of their code from GPL to LGPL. Now, I didn't like their policy decision, but they did an excellent job in implementing that. They contacted every copyright holder and got permission to relicense. So these things can be done, but they're complicated if you are stuck in a V2 only world. But I think that the way, even having seen all this happen, I still think it's right to let the copyright holder decide if they want only or later. That's something that each individual author should have the right to choose. I think it's wrong for Mozilla and Eclipse and CDDL to let some other entity. I mean, think of CDDL as an example. Now, it kind of helps us here, right? Because they could change the CDDL and fix the GPL compatibility problem today. But on the other hand, when people were contributing to Open Solaris, right, they're doing so under CDDL, and they're basically giving Sun permission to change the license of their own code. And then when Sun sells to Oracle, suddenly Oracle has the right to do that. And it's your code, and they have this unilateral right forever to change the license on you. That's a little scary. I think people should be able to choose if they trust the FSF or not. I don't think the FSF deserves implicit trust. I don't think any organization deserves implicit trust. We should be able to test these questions, and if people want to choose an only V2 only, V3 only license, they should do so. The world's a complicated place, right? It's okay if the licensing structures are complicated, if it means that people get the rights that they're supposed to have. Did you think of something specific about Google v. Oracle you want to ask about? Yeah. So if you think of something, or we can talk over dinner or something about it in more length. Or if nobody has, do people have more questions that aren't about Oracle v. Google, and then I can just go in and talk about Oracle v. Google forever?
When you asked for what topic we wanted, I mentioned that I wanted to hear about the GPL, because I like Copyleft, but I have for some time felt that even though we on paper are strong, the reality for users is weak, because we depend more and more on services as opposed to the software itself.
Mm-hmm. So the question is about the Affero GPL and the fact that it covers copyleft in the network service age. I'll give you the 5-minute version of my talk on Affero GPL that you wanted me to give. I had a feeling you might be the only person who wanted to hear a whole talk on Affero GPL. I do have one that I've written. But the 5-minute version of that is basically the FSF discovered in the 2002 era, Henry Poole, a fellow who was starting a web services company, was really the first to notice this was a huge problem, the problem you just described. So he came to the FSF and said, hey, you need to write a license that covers this. And I came up with the idea of using a program that prints its own source code. So you could put a feature in the GPL that said, if the program can print its own source code to the user, you may not change that, remove that feature, and that feature must always print the complete corresponding source code. So that was the original idea. It's a little more nuanced now than that simple print your own source code idea, because printing your own source code is confusing to non-technical people. But the lawyers have worked on it a few times and made iterations of that idea. But I think the idea is correct. I think that Copyleft should have extended. I actually wasn't involved very much in the drafting of GPLv3. It's one of the things I regret. It just, accident of history, I wasn't as involved as I would have liked to have been. And I was actually surprised to learn late in the v3 process, like 6 months in, I discovered that even in the earliest documents announcing the GPLv3 process, the decision had already been made by the FSF not to include the Affero clause by default in GPLv3. And there were a number of different political reasons that happened. I've talked to Richard Stallman a great deal about it because it concerns me personally, and I care in part because I came up with the idea of the Affero GPL, but also because I care about this network services issue about not including it. And Stallman's view is that having a separate license that does it is a way to let developers decide. And so if developers feel that network service freedom is important, they can use the Affero GPL, which guarantees if you deploy the software on the network, then all the users on that network get the source code. Unfortunately, it has not been widely adopted by community projects. It's been adopted by MySQL-like companies. So companies that want to scare people about copyleft so they buy a proprietary license. And that's the most common use of Affero GPL. It's really upsetting to me as the person who invented the license. I'm embarrassed to see these people using it to basically shake people down and be like, oh, the Affero GPL is so scary. What you want to do is buy a proprietary license instead. You see lots of VC-funded companies with a community edition under the Affero GPL and then the enterprise edition that you buy separately that doesn't have, you don't have that scary Affero GPL to get in your way. So it's unfortunate that's happened. I think the best thing to do about it is developers need to start developing community-oriented free software projects that give network services. There's a number of people who have tried to do that. The only project I know that's really successful in that area is GNU Media Goblin, which is a distributed media system. But right now, all these services tend to come from big companies. You know, Twitter, Google, Facebook, all these major network applications that people use are from big companies that have total control. And they wrote the code bases from scratch. So it's not like they're even using GPL code anyway. They're writing their own stuff and forcing it down our throats. I mean, I think people need to take a stand. I don't use any Google services like Gmail or Google Docs or any of that myself. I refuse to. Because from my point of view, it's just proprietary software. I mean, I don't want to use it. But we need more people writing software like that. And it's going to have to be done by community people because no company wants to do that. Companies want to make it and sell it to you as a service. We need community members who care about software freedom to write it for their own use, just like how most of the other free software started. Linux was started as a hobby project, just a hobby, not big and professional like GNU, right? And we need the this is just a hobby network service. I want to replace Google. Not big and professional like Google. I just want to do a little network service of my own. We need people to do that on their free time. I think we need people, a lot of developers who have high-paying development jobs, they end up having a lot of, developers get paid pretty well. And they have resources and they have free time a lot of the time because they can, when they come home from their proprietary development job, they can write free software. That's how much of the early free software got written. People who had jobs writing proprietary software on their weekends, they decided to write free software. We need more of that again. That's the only way we're going to solve this problem. And the license is there for them to use. Affero GPL exists, but the software is not there yet. And that's the way GPL succeeded, was people wrote software that everyone wanted to use under GPL, and that's why we have Linux. So we need that in the network services space. I'd be working, if I wasn't doing this, I'd probably be working on that. But unfortunately, I'm the guy in charge of enforcing the GPL. So I need to be here when there's a good Affero GPL program that gets violated. I can come and do it. I actually did contribute to an Affero GPL program for online poker. So I'm also a poker player, and there's a system called PokerSource, which is a completely Affero GPL free software online poker system that unfortunately nobody uses these days because they all use the proprietary poker sites. But oh well. I tried. So, yeah.
Another one is that a couple of years ago you were on Linux Outlaws.
I was on Linux Outlaws, I think 5 times. By the end of Linux Outlaws, I was the most frequent guest. Yeah. I'm very proud of that. Anyway, so which time are you talking about?
It was the dark ages of free software.
Oh, yes. I do think we're entering the dark ages.
Lots of good points. But then we were talking about a library, about double accounting systems.
Yes, double entry accounting. Yeah. So we're about to hire somebody, hopefully, at Conservancy. So the question is about a project that Conservancy launched that has not gone very far yet. to make, I talked all about GPL enforcement here, but we as an organization, the Software Freedom Conservancy, provide all sorts of different services to free software projects. One of the big things we do is actually handling financial contributions for free software projects. So we have about 30 different member projects, some of the projects you know, like Git and BusyBox is a project and so forth. And if you want to donate to one of those projects, you can through our organization, and then they have a special fund for their project that they can use to fund developers to go to conferences or all the sorts of things you might fund. We even have many projects that raise enough money that they hire developers to work as contractors on the software. So instead of being employed by a company that lets them contribute some of their time back to the project, they're employed directly by the project to work specifically on the project's needs. But of course that requires accounting, right? You have to keep track of money and paying bills and doing travel expense reports and so forth. And what we found is there is no really good free software that does this, particularly for the complex situation we have, where we have 30 different earmarked accounts, all of which have different bills coming against them. No one has solved this problem in free software for accounting at all. And so we started working on a system to do this. I have sort of this hack together system that I built that it's keeping the books as only a hacker could, right? I keep all the books in version control and ASCII text files, and I have command line scripts and so forth, which means I still keep the books of Conservancy because we would have to hire another developer who knew version control and all this other stuff to do it. So we want to build on that system as a base and build a system that we can actually hire a person who just keeps books, doesn't know how to use version control and so forth to keep the books. And that's a project we launched. We didn't reach our fundraising target for it. All we were able to get done was we did a survey of what free software is out there and what parts we can reuse to do this, because we want to reuse the code that's out there. But fortunately, we did raise enough money in our most recent fundraiser we can hire another employee. So the hope is we're either going to hire an employee who can take some of the administrative work that I'm doing so I can focus on that project, or we'll hire a developer that I'll work with. We're not sure yet. We're interviewing for both types of candidates. But hopefully in the next maybe 10 months, we'll be moving again on that project. So it's just been stalled because of resources. And it's very, very hard to get funding for infrastructural software like that. Unfortunately, most charity, it would help nonprofits all over the world, but most of them buy one of the proprietary applications that exists. And so it's like replacing any proprietary software. You need a little bit of funding and some volunteer effort to get it going, which we're trying to get going.
Yeah, it would have been great to have another, like you said, it's probably one of the most reinvented
Yeah.
Is it on Savannah?
So the stuff that I've done, I've upstreamed to Ledger. So the point that you're asking about is a specific point I talked about on that podcast, which is that one of the design goals of the general idea, what we saw in our survey, we surveyed all the free software systems that do accounting, and we found that people develop things only for vertical markets. Like there's a really good free software project for doing automotive parts stores, right? So you can, if you want to open a store that sells parts for cars, there's an accounting system for you. But everybody re-implements the basics of it, which is double entry accounting, which was invented in Italy in the 1500s, basically. That's been re-implemented over and over again, and everybody re-implements their own library that does it. So the first thing we want to do is make a really clear API, which has never been done, I think, in history for double entry accounting, and then build accounting applications on top of that, so that you kind of have a horizontal market of there is a single code base that everybody uses, and then in their vertical market they add whatever features they need for nonprofit accounting, which is what I'm interested in, or automotive accounting, or whatever it is. So long term, I think we want to do that. The little bit that I've done on it so far is all in the Ledger CLI project. There are really two projects that I think can be adapted into that library. It's either the Ledger CLI project, or there's another one called Bean Count, which is in Python. So one of those two would probably be the right base. So I think when we get started on the project again, we'll decide which one to follow. I think Bean Count might be better. It's not as advanced as Ledger CLI, but Ledger CLI is in C++, and Bean Count's in Python, and just the ability to get more developers in Python is going to be true. There's a lot more Python developers than C++ developers. So.
I totally work with software because,
Yeah.
first of all, I do accounting.
Uh-huh.
I'll be refunding some of your costs later on. And it's a lot of hassle.
Yeah, yeah.
Really, even for the small numbers, it's really a lot of work.
Yep.
Especially, and also, one of our biggest obstacles for getting money is actually billing.
Yeah.
And there's services that will let us bill, but first of all, they put their name on it, which makes it really icky. And second of all, they actually charge for it. And I basically just wanted to print the numbers that I tell it in
Yeah.
And second of all, because the infrastructure of my personal economy is like a small business.
Yeah.
And I would love version control for that.
Yeah. Well, I mean, so the point is that the question is, the comment is, they would love, the software would help a lot of people and would be good because it's very difficult doing accounting, even for your own personal business, it's difficult. So if you know what version control is already, you could actually use the system I use. I use Ledger CLI with a series of tags and has a tagging system. And so I use the tags, and I did write a tutorial that's online as well it was on Gatorius, and then Gatorius went away. And so I can probably move it to, I'll make sure after the talk that it's on at least Conservancy's GitHub account. We actually have a Calathea, no, it's on our Calathea instance, because I don't like GitHub either for various reasons. But we mirror things on GitHub, but we use Calathea, which is a free software code repository management system. I wrote a tutorial that explains how we use Ledger CLI. So if you already know version control and you're comfortable with command line, you could use what we use at Conservancy today, because you could just read the tutorial of how I do the tags and reports. And so it's probably already there for you. Our problem is that you have to know how to use version control, edit text files, and run things on the command line, which a skill set probably you have, but the average bookkeeper does not.
I cannot imagine.
Yeah.
The account.
Yeah, exactly. Actually, our accountants, it turns out, so I generate reports, and I've written, this is upstreamed in the contrib directory in Ledger CLI. I have these reports that generate basically just spreadsheet reports for all the reports accountants like to see. And I actually have it's a pretty neat system that it generates a LibreOffice spreadsheet, and it links to all the documents. So using my tagging structure, like the invoices are all tagged to the transactions they relate to, and then when I generate the reports, the general ledger report that they get, each general ledger entry has a link to the invoice that relates to it, and they just click in the spreadsheet and it pops up the invoice that relates to that. And they actually really love this, right? So it was funny at the end of our last, so in the US, charities have to be independently audited every year because our books are made public and then they're audited by a third party to verify we're not lying. And that we're actually telling the truth on our public filings. And so the auditors at the end of the process, I had this conference call with them, and he said, you know, you're actually a pretty good accountant for a software developer if you ever want to change professions. He was impressed. I mean, because the fact is, accounting is just math. Actually, I love our auditors, because one of the reasons why we switched from this thing called the cash basis to the accrual basis, people who understand accounting know what that is. And because we were small, a lot of small organizations use the cash basis, but accrual basis is considered the proper way to do it. And the way he pitched me on it, he said, well, let me tell you about this, I forget his name, the one who invented double entry accounting in Italy in the 1500s. And basically it's a story of math, right? So he was writing this big math book in Italy with the principles of mathematics for the city-states in Italy in the 1500s. And of course, like most things in that era, and then today as well, there was a rich patron who was funding this work. And this rich patron goes to this, of course he's writing regular mathematics that we think of as mathematics. And this rich patron goes to him and says, well, my rich friends and I have this problem. We don't know what we own, and we all want to compete with each other about how much we own, so we need a system to keep track of what we own so we can show off to our friends. And so he invented double entry accounting and the accrual basis as a system for keeping track of what you own and what your assets are, so you can know if you have more money than your friends, right? I mean, this is a thing that rich people in Italy in the 1500s really need, right? Because they have to show, well, I have this many ships, and there's this much product on these ships right now in the Atlantic, whatever. So this was a mathematical invention of how to keep track of stuff, and that sold me on the whole accounting idea. It's really, if you're into math, accounting is just a type of math. It's just been hyper specialized into thinking of it as a business thing, but it's really just math. So and this is why, to answer your point, I think that we have to treat it as a math library. Like, we've never said, like, gee, let's write square root again every time we write an application, right? We don't do that. We use a library. But with double entry accounting, everybody says, okay, I'm going to write an accounting system. Let me rewrite double entry accounting from scratch again. There should be an API for that, right? And it should just be a standardized API. And as I said on the podcast you mentioned, I said, I think it's the most re-implemented thing in history, because the first software programs written in COBOL were double entry accounting systems, right? So if you go back to the 70s, we've been writing double entry accounting over and over again. We should write it once, like a library, and just use it. So that's what we want to do.
Thank you so much.
Yeah, thank you.
You can give me your applause.
Thanks. Thank you, everybody.
And then there's the T-shirt.
Oh, well, thank you. I stood on camera. Yeah.
So we're just going to tell you what we tell, or most girls get wear. You can wear it in your sleep if you don't wear it at daytime.
Yeah, I usually, I try to be halfway between like hacker and business. That's why I wear sneakers and a button-down shirt. But on planes, I always wear t-shirts because it's more comfortable. So I will wear this on the plane home.
Yeah. You should be very happy to hear that we actually have made sure that we are allowed to use all the parts.
I heard that. I was told that before the talk. So thank you very much. Thank you, everybody. So I think there's probably I guess it's a little early for dinner yet, but is there a plan to go out to dinner with a group or?